Further hearing in the appeal, Chen against whom?
Mr. MacDonald.
My Lord, my first and painful duty this morning is to apologise to Your Lordship for having delayed the start of yesterday's proceedings. I'll explain how that arose in a moment, but I would have made this apology yesterday morning had I realised that Your Lordships had been waiting for me. I'm afraid that when I got into court, I was reassuringly told by the court staff that Your Lordships would be another 10 minutes. And I foolishly interpreted that as meaning that my lateness had escaped notice. But, since that, I understand through Your Lordship's clerk this morning that that was not the case. May I explain? I had arranged yesterday to leave my house at in Rutland Street, just off the Brompton Road, at 9:30, and my clerk was to come there to fetch me with the boxes of papers at 9:30. The taxi, which he'd been arranged for that purpose, took 45 minutes to get from Waterloo to Rutland Street because of the closure of Parliament Square, I gather. And so the taxi didn't arrive until 10. We left immediately, and at 5 to 11, thanks to the road closures, we were still in Victoria Street next to New Scotland Yard. At that point, I got out and walked and got here at 11 o'clock. And I would, of course, have apologised to Your Lordships had I realised that Your Lordships had been waiting for me.
Well, the reason why we...
I make that apology now.
Yes, thank you very much for that. We are grateful for the apology, and we did, in fact, put off sitting till 11:20 because we were told you were not able to be there till about 11:10 or 11:15. But thank you for your apology and explanation.
Having learnt the lesson from yesterday about the current state of the roads.
You spent the night here?
Got here. It arrived at 10 o'clock this morning.
Good. Thank you.
Lord, when Your Lordships, or shortly before Your Lordships rose yesterday afternoon, as I understood it, Your Lordships were hoping to hear from me what had been said in the pleadings and evidence about the transfers.
Well, you told us yesterday what had been said in the pleadings. The question really is, what is your response to Mr. Parker's essentially 2 points about the judge's misconceptions at paragraphs 33 and 4 of his
Yes. Well, I've been thinking about that overnight, and may I put it in this way? By way of, I'm going to make I hope, succinct submission about that shortly, but by way of preface, may I take Your Lordships through the way the evidence accumulated, shall we say. Your Lordships have probably gathered from comments in my case that Mr. Commenced the proceedings initially simply against Pexon and applied for summary judgment. My client applied to the court to be added as a defendant, and she opposed the summary judgment application by filing an affidavit on the 7th of December 2012, which is in volume 3 at tab 12. If Your Lordships would just briefly glance at that.
Sorry, what's the reference?
3 tab 12.
Volume 3.
It's 03.
Yeah, okay.
Yep.
Volume 3 at tab 12
Yes.
begins paragraph 1. I make this affidavit in opposition to the claimant's application for summary judgment in reply to Mr. Evidence. And then, if in paragraph 59, page 314 of the bundle, there's a long passage in the affidavit which continues down to paragraph 88, headed "The events leading to the 4th October 2011 transfer." And based on the rest of her case, in paragraph 78 there, she says that following the adverse publicity about Mr. Which had been in the newspapers in July, and she's previously said at 67 that the mainland police had actually contacted her earlier in the year looking for Mr. and she didn't tell them where they could find him. She says that I believe that the legal title to the shares owned by me beneficially was in jeopardy and couldn't continue to be held by Mr. So I once again demanded Mr. honour and perform our 1996 oral agreement, and it was because of this sequence of events that on or about 4th October he honoured and performed the agreement by transferring legal title back into my name unconditionally. And then she deals with the individual documents at paragraphs 82 to 88. And in particular, she says that the board minute with the chairman's report and the declaration, this is paragraph 87, were in Chinese. Mr. speaks and reads Chinese and read these documents before signing them. So that was what she said in answer to the summary judgment application. And the summary judgment application did not proceed after that. And then witness statements were exchanged before the trial on the 7th of October. That was 2 weeks before the trial. And Mr. witness statement, which your lordships will find in volume 4 at tab 8, refers frequently to Madame Chen's second affidavit and addresses it. And of course, a lot of it is to do with the early days and his successful refutation, successful as found by the judge, of her story as to how the Pexon had been acquired, leading to the conclusion that she'd always been the beneficial owner. But at page 478 of the bundle, he comes...
478?
Page 478, my lord, paragraph 124, it begins, headed Dealings with Madame Chen. In that section, he deals with 3 share transfers. First of all, he deals under the heading Eastern Technology share transfer. And your lordship may remember, because this has been touched on in the judgment and in my learned friend's submissions, that Mr. Said that she had some shares in a company called Eastern Technology, originally intended to develop a technology park, but that became impractical by 2003. But it had some land which Madame Chen suggested they try to redevelop in 2008, para 129. She applied as a shareholder, and when that didn't progress, in 2010 he asked for the shares back, and she returned them, para 129. Her case on that had been para 131, that she didn't intend to transfer them to Mr. beneficially, but only as nominee to keep them safe from litigation that she was threatened with. And Mr. says that he doesn't believe that and it was wrong. That wasn't, in fact, important at the trial, but they both stuck to their cases on that. More important was the next heading, where Mr. dealt with what he called the Greek mythology share transfer. And he sets out his version of the development of plans for a United States listing of the company which operated the casino, see para 135. The goal was to list in the United States. Para 137, he was informed at a meeting with the potential underwriters of this listing project, C136, informed by Mr. Lee Wing Bun. He doesn't figure in the story anywhere else. He's not to be confused with Lei Kern, who we call Kern Gore. But he was to be the agent for the purpose of this listing project. And 137, he was told by Mr. Lee and Madame Chen, wasn't controversial, that the underwriter had expressed concerns regarding potential difficulties in effecting a listing in the United States due to negative publicity surrounding me. And so he transferred the remaining shares in Greek mythology to Madame Chen. And then 141, and it's important to bear in mind when considering the judge's finding, in which he attached significance to the fact that Mr. Did not require a blank transfer from Madame Chen, that he volunteers here. Mr. Lee Wing Bun suggested to him in 2007 he should have Madame Chen sign a blank transfer, since the transfer of the Greek mythology shares at that stage was only temporary. It was prepared by Lee Wing Bun, gave it to one of my assistants, take to Madame Chen for signing, and found that she had signed it a few days later. So that was where that came from. It was volunteered by Mr. And then page 485, he comes on to the transfer of the press shares. And he sets out his story, starting with the Katai Strip project and going on to the Apple Daily article, which he says caused Madame Chen to say to him she'd better take over the Katai Strip project.
Yes.
And then he sets out the various formal documents of the 4th of October and subsequent, without questioning their authenticity. Para 161, he says we both understood at the end of that paragraph that it was to be it was a temporary transfer, and that I'd only transferred the legal title to her. Sorry.
Why precisely are we looking at this in so much detail?
Beg your pardon.
Why are we looking at this in so much detail? I understand your point that he deals with the blank
Well,
141.
I was asked what had been said in the evidence about the documents, my lord, and I'm going to come on to what was said in the oral
Yes.
evidence as well.
I mean, what we're really getting at is whether the judge was entitled, because that's the argument, to make the finding that he did about Mr. Ng's evidence on the basis that he made that finding.
Yes, my lord, I'm leading up to that.
Right.
And my submission on that, I hope, will be quite succinct. But
Okay.
then Madame Chen's witness statement, which was exchanged for that,
Yep.
simply repeated on this part of it what had been said in the summary judgment affidavit.
Right.
I don't need to trouble your lordship with
Just
more
for the
than
reference,
perhaps
just the reference.
Paras 1, if your lordship's note, paras 193 to 228 repeat almost verbatim paras 59 to 88.
That's very helpful.
The
That's
second.
page 539 and following.
It starts at 539.
Thank you very much. Thank you. That's very helpful. Thank you. Yeah. Okay. So that's the witness statement evidence. Yeah.
My lord, the submission that it was all unfair to Mr. When we dealt with it at the in closing speeches and when the judge finally disposed of it in his judgment, because it was common ground that the transfer did not include the beneficial interest. That proposition, I'm repeating one of my opening propositions in our case, is only true in the sense that both parties said that as part of their diametrically opposite cases. It could not be submitted, for example, that it was all unfair to Mr. Because, quote, it was common ground that Mr. retained the beneficial title, unquote. That was not common ground. Yet that was the question which the judge formulated. Did Mr. retain the beneficial title? It wasn't common ground formulated in that way at all.
Well,
It was not Mr. case at the trial that the beneficial title remained with him because Madame Chen said the transfer did not include it. That proposition would have, or that submission would have seemed absurd to Mr. own team as well as the judge, because their task was to overcome her case that the beneficial interest had always been in her. Instead of focusing on that, they advanced the previously unheralded and unpleaded case that the beneficial title remained with him by way of resulting trust because the transfer was gratuitous. There was nothing about that in their pleadings.
I understand, but that's not really the issue in the case. The issue was the judge entitled to reject his evidence for the reasons he gave?
We defeated that submission by reference to, as far as the judge was concerned, by reference to the terms of the admitted documents. We also put it on the basis of estoppel by convention, which it's now accepted that we had pleaded, but the judge simply put it on the basis of objective construction. Primesight and Lavarello, which had not yet been reported when he gave judgment, shows that he was right, because Primesight and Lavarello focuses on the need to construe the legal documents which the parties have entered into, and explained why the fact that a consideration stated had not been paid was irrelevant.
Yeah.
What has happened is that Mr. Ohm's new team opportunistically built a completely new case against Madame Chen on the basis, one, that because she'd said at the trial she believed the beneficial interest belonged to her all the time, so that the transfer on her submissions only passed the legal interest. She continued to be bound by that evidence, even after they, that's to say Mr. Um's team, had persuaded the court to disbelieve her. And two, that was their first problem.
The basis on which she contended that she'd always had the beneficial interest was that she said she'd provided the money.
Yeah.
And out of the great fortune that she had accumulated by running hotels, one with a casino in China. And the judge rejected that, so he cannot possibly have believed that she ever had a beneficial interest unless she derived it from the 4th of October meeting, transaction.
So he approached the attempt to understand what happened on the 4th of November on the basis that she didn't originally provide the money and that she had no basis for saying that she'd always believed that the beneficial interest was in her.
What are we considering? Are we considering what I've called the first point, or are we considering the evidence point at the moment? Because if we're considering the evidence point...
I'm coming on to what was said in a moment.
But which point are we considering at the moment? Because if we're considering the evidence point, I'm not sure where this is going. As I understand it, we've dealt with the issue about whether the judge was entitled to come to the conclusion that he did as a matter of principle. And we're looking at whether the judge was entitled to conclude, for the reasons that he did, that he rejected Mr. Ng's evidence.
What I'm leading up to, my Lord, is showing that what was said at the end of the trial, on day 6 in our closing speeches, with a view to persuading the Lordship that there was no unfairness at all. My learned friend, your Lordship, remember, kept reiterating that it was a case which had never been pleaded or put. It was both pleaded and put.
Well, we've been through all that, but what I'm concerned about is, and I thought this is what we were addressing, is whether the judge was entitled to reject Mr. Ng's evidence for the reasons that he gave. The issue which we thought Mr. Parker should open on, and which I understand that you're replying.
Yes, very well, my Lord. The reason why the judge was entitled to take the approach that he did was because whether the transfer left the beneficial interest in him was a matter of objective construction of the admitted legal documents. Now,
that we've been into that, but
well, we haven't. Well, I'm sorry, Lord, I mustn't contradict you.
I think that yes, but as I understand it, the issue which we're considering is a different issue, which is the reason the judge was entitled to do that, you say, is because he rejected both sides' evidence. Yes?
No, the reason he had to do it was because that was his task on the resulting trust point anyway.
That's the way you put it, yes.
Well, Lord, it's the way Lord Upjohn.
Yes, the way Lord Upjohn put it. But what we've been through this, and I think we're going over the same ground again. What we want looking at the evidence for and the cross-examination for was to deal with Mr. Parker's point that the judge was not entitled to reject Mr. Ng's evidence for the reasons that the judge gave. And I think that's what we should be focusing on. As far as I'm concerned, we've had the argument on the first point.
Well,
and we're now straying into other argument.
Sorry.
And you've got 3 hours for putting your case, and we haven't even got on to the question of the submission to jurisdiction. But what I'd like you to focus on, for my part, is whether the judge did go outside what was permitted to him as the reasons for rejecting Mr. Ng's evidence.
Well, the first reason he gave was that Mr. was bound by the documents. That is based on the principle stated by Lord Upjohn in Vanderbilt, which has been followed and applied many times, including Westdeutscher, and which I would invite your Lordship very, very briefly to look at. It's only 2 paragraphs. Volume 18, tab 6.
Going back over the same, this is just going back over the ground we've been over, as far as I can see. Mr. Ng said that there was an agreement that these shares would only be transferred to Madam Chen on the basis that she would transfer them back after 6 months. The judge rejected that, and Mr. Parker says that the judge was not entitled to reject that evidence for the reasons he gave, because the reasons that he gave weren't put. Now, how Lord Upjohn can help on that, I cannot imagine.
Well, there are two stages. If your lordship is simply concerned with how I deal with the judge's rejection of the Thai strip project story, then I've dealt with that already. I'll come back to that in a moment.
Well, as far as I can see, what you're going into now is what you've dealt with. We've been through that yesterday.
The judge found as a fact that Mr. transferred the legal and beneficial interest to Madame Chen, and he found that as a fact because it was a matter of correct objective construction of the documents. What Lord Upjohn said at page 312 in Bundle 18, tab 6, where A transfers the legal estate to B otherwise than for valuable consideration, it's a question of the intention of A in making the transfer, whether B was to take beneficially or on trust, and if the latter, on what trusts. If as a matter of construction of the document transferring the legal estate, it is possible to discern A's intentions, that is an end of the matter, and no extraneous evidence is admissible to correct and qualify his intentions so ascertained. And that was my answer to the judge's comments during my closing speech, that I had not put these documents, these legal documents, to Mr. The reason why I didn't put them to Mr. as I said to the judge at the time, was that they were authentic documents which had not been challenged by Mr. himself, by way of saying he didn't understand them, which has no legal relevance. And therefore it was quite unnecessary for me to put them to him. I relied on them as his documents, which he produced in his written statement, with simply the explanation that partly he didn't understand them, and partly he only signed them because of the Thai strip agreement.
I understand that, but does that mean that you do not seek to defend the judge's grounds for rejecting Mr. Ng's evidence?
Of course I do, my lord.
Well, in that case, I'd be grateful if you'd concentrate on why you say Mr. Parker's wrong. It's paragraphs 29 to 34 or 35 of the judge's judgment on pages 179 to 181. I know you say it's unnecessary for the judge to have gone into this, but if we take a different view, you may want to answer Mr. Parker. We have your point, and I see the point. Yes, I see your point about what you say about what Lord Upjohn says. But nonetheless, you may want to answer what Mr. Parker says in case we take a different view on that submission.
Yes, 39 is where the judge deals with the effect of the document.
Yes.
Mr. can't show the transfer was gratuitous because his own documents contradict, etc.
Yeah, I know all that, but I'm asking about the judge's rejection of Mr. Ng's explanation.
Well, he said I mean, you say he can't show it. As a matter of evidence, anyway, you'll come to it, but I would have thought he could show it. He was trying to show it, but he was disbelieved.
Yes. Well, you say the documents speak for themselves and you can't go behind the documents per Lord Upjohn. If you're right on that, cadet quaestio, but if you're wrong on that, Mr. Parker says that the rejection of Mr. Ng's explanation is unfair for the reasons he gave. And the only aspect of the case on which I think we haven't heard from you is whether you accept that or whether you reject it, and if so, why?
Well, as far as the Katai Strip project explanation is concerned, it was quite clearly put to Mr. That his explanation was untrue.
Give us a reference.
Put the reference earlier in my notes, but it's probably quicker if I find it again.
You want a notebook?
I'd like a notebook. It's in bundle 5, I believe. 05.
Yeah.
My recollection is that you put it to him, but not for the reason which the judge found. You put it to him that it was not true because the real reason was that he wanted to put the shares in Mrs. Chen's hands where they would be safer from his creditors given his financial difficulties, which I think was not a point which the judge found in your favour.
My cross-examination on that started at page 634 in
Yes.
Bundle 5, Tab 5.
The part you took us to yesterday, you're quite right, yes.
634. Now, did there come a time, line 8, when you were proposing to build a new building near the hotel? And he said he had no partner, but then admitted his partner was John Gong, who had invested 100 million US in the project. Page 37, line 17, it didn't proceed, did it? No, it did not. Why was that? Because she said she would go to Beijing to apply for the project. But I said you fell out or had a hostile agreement with John Gong, whom we'd established as your partner, didn't you? And then I put to him his complaint to the Macau Judicial Police, which was detailed and had various warnings by, for example, the FSA in England about John Gong's company. And then he said, well, I did go on with it after John Gong and I had fallen out because I prepared the feasibility report. This is page 640 at line 9. The feasibility report I think we looked at yesterday, or at least
Well, yes.
Sumption asked for the reference and that was given.
So he referred to the feasibility report, which at line 9, which the judge founded on. Yes.
Yes, and the significance of that was that it emphasised the importance of Mr.
Yes.
personally to the project.
Yes, because I think the point that the court is looking for guidance on is the basis of the judge's conclusion that putting the shares into Madam Chen's name was futile. And what is the basis on which the judge was able to reach that view?
Perhaps your Lordship should have just glanced at the feasibility report.
Why?
It's quite an important document.
What are we looking at it for?
Well, it certainly vouches the passages that the judges refer to. That is clear. But you're saying, is it, that he was entitled to, given that the witness had referred to the feasibility report, that entitled him to look at it and quote these passages? Yes.
Yes, I see.
But given
No, well,
sorry, please.
listen to the question.
Given that his evidence was that he was in some difficulty by being accused of a scam in relation to the Social Security Fund, why is it that the judge could conclude that using Madam Chen to front the project was futile?
Because the project was still a project of Chong Gold. Chong Gold, the feasibility study and business plan, which is the name document in the bundle, professionally produced to explain the project, made it quite clear that Mr. was being presented as essential to the project.
And so the merely having the shares in someone else's name was, to your mind, irrelevant? Yeah.
Well, the point was putting the Chong Gold shares in Madame Chen's name would have been the basis on which she could appear to make the application instead of him. But putting the Pexon shares in Madame Chen's name so that she could present Chong Gold's proposals with the clout of the owner of another substantial Macau hotel was simply not credible, because it couldn't, from the point of view of a realistic businessman, achieve the result which he claims was the purpose of the transfer.
And your purpose of taking us to that feasibility report is simply to show it's got Mr. Ng all over it?
Yes, but
yes, I see.
If we just turn it up for a moment.
Yes, very briefly, yep. Bundle? Bundle?
14, volume 14.
Thank you. Right.
It's 14 tab 11.
Yep.
And at page 2556 is, I think, the reference.
So there's Mr. Ng.
Page.
Yes, yeah, 2556, yeah. 2556, yes.
This is a
And management team is Mr. Ng, is that to say?
risks associated with the key person, page 2556.
Management team.
Management team led by Mr.
Yes. Yes, I see.
etc.
Yes, I see. Thank you.
So the purpose of the cross-examination was to show that Chong had dropped out at some point and been reported to the judicial authority. Can we just date that?
Which page in the cross-examination law?
It was...
Well, did Chong drop out? I thought it was simply Mr. Gong who dropped out.
Yes.
sorry, I meant Gong, yes.
He said Chong Gold continued
was the 5%
under his leadership.
Yeah. So it's
Mr. Gong had fallen out because he...
Gong, I see.
That's right.
Mr. Gong had owned 5% at one stage of the shares.
Yeah, well, wait,
He dropped out.
US, he
Yes,
said
and he dropped it and invested 100 million. Yes. And he dropped out after a row with Mr. Ng.
Well, does that mean Chong dropped out?
No.
Well,
It means Chong Gong dropped out, but Mr. remained the majority shareholder of Chong Gold, and the key person, according to his own feasibility study. Just for your Lordship's note and for the chronology, the complaint by Mr. to the
yes.
police is
Page.
13. The next document after the business plan, and it's dated the 27th of April, 2011.
Yeah, wait a minute, but the essential point is you say that the reference to, forgetting Mr. Chung, that if we look at the judge's reasons, which is what we're concentrating on here, you say that the futility point is made out once one looks at the very document that was put to him, the feasibility report.
But it wasn't actually put to him.
But it wasn't put to him in that, exactly. Yes.
He simply referred to the fact that he had prepared it.
Yes. I put it to him that his evidence that the project remained alive because he prepared these documents was wrong, because they'd been prepared before he fell out with Mr. Gong in March 2011, which he accepted. See page 641 of the volume with the transcript of day one.
Yes.
And then, having made it quite clear to Mr. that I was challenging his story about this, I then switched, bottom of page 642 of the bundle, line 24, to the alternative explanation which I suggested to him, which was that the most important problem for him by the middle of 2011, when the adverse press publicity appeared, was his financial difficulties.
Yeah, but the point being made is if you look at paragraph 31 and 32 of the judgment, the judge's primary reason for rejecting Mr. Ng's explanation was, in 31, passages in the feasibility study, which, as the judge says, were not put to Mr. Ng in cross-examination. And secondly, supporting a submission you made that it was irrational to suppose that a transfer of the shares could assist to promote in Beijing a project which was on its face a project of Mr. Ng's. And the point made by Mr. Parker is that that was never put to Mr. Ng. Now, is that right? And if it's right, what's your answer to the fact that it was unfair of the judge to rely on that as a reason for rejecting Mr. Ng's evidence?
The judge, when he considers the evidence as a whole, is quite entitled when he...
Did you accept that it wasn't put?
I accept that the fact that the feasibility study had, as was said yesterday, Mr. Ng's fingerprints all over it, was not put to Mr. Ng himself. But again, it's self-evident from the document.
Right, but
the judge has to evaluate has to make his findings of fact based on the evidence that he's been given. And the judge was quite entitled, in my submission, to make the 2 points which he made. Mm-hmm. Number one, that Mr. did not get a blank transfer or any sort of written acknowledgement that the shares had to be returned. He was quite entitled to make that, or to treat that as a material factor in his factual conclusion, because Mr. had actually volunteered that he'd done that on a previous occasion in his witness statement. And then, as we said in our, suggested in our case, he had lamely volunteered in his witness statement in chief that he hadn't done that this time because he trusted Madame Chen.
So your submission amounts to this, that, as I think anyone would accept, nobody is obliged in every case to put every point to a witness, and that must be right. And it's a matter of degree and, by reference to the facts of each case, whether it's unfair for a point to have been decided without it being expressly put. And in this case, it was not unfair.
It was not unfair, Lord, no. And
yes.
In support of that, may I ask your lordships to look at the only authorities which have been relied on
yes.
for the suggestion that it amounted to an unfairness which an appellate court would use as a
Yes.
and he should
Yes.
set aside the judgment below. And my lord, those cases were, I'll leave Brown and Dunn till last, but those cases were Almudeni and Mars and Markham and Zypher.
I would remind you that you did indent for 3 hours.
Sorry?
You did indent for 3 hours, and you are well over the 3 hours, I suggest. So let's make this speedy.
I simply need to show you...
Well, I understand you need to, but let's make it speedy.
Yes, Lord. Can I simply point your lordships to what we said in our case in great detail about those three authorities?
Yes, of course. Yes.
Our case, para 44, and I won't
That's very helpful. That's a very useful way of doing it. Thank you. Page 75 of the bundle, yep. Yep. You say the issue in this case was whether he was telling the truth. The issue in this case was whether his story was true. And the judge did adjudicate on that issue. I understand that. Yep. We're looking at paragraph 44.
Markham and Cypher we've dealt with in our case at 114 to 117.
Yep. Yes. Yep.
The point there was that Judge Feisch, hearing this dispute over the originality of patents between the two competitors, in a situation where employees have moved from one competitor to the other.
Yes.
Para 115 made adverse findings against the employees who moved from Markham to Cypher.
Yes.
His findings were so insupportable that in the Court of Appeal, counsel for Markham had conceded that they were wrong. The Court of Appeal nevertheless dealt with them because the judgment of Judge Feisch had besmirched the reputation of the...
Yes, yep.
And then, in the case of the managing director, counsel for Markham had never invited the judge to find that the gentleman's in question's evidence was false.
Yes, I see how you say it's a different case.
In the case of the three other Markham employees, last sentence of 117, counsel for Markham had actually confirmed to the judge that he was not making any specific attacks on any of Cypher's witnesses. Their evidence could be true,
Yep.
in his case didn't terminate.
Yes, I understand.
Having
yes.
Feisch, in his judgment, had found that they had concocted their evidence, a tissue of lies.
Yeah, well, I can well see how you distinguish.
That was a...
Yes, I can well see how you distinguish that case.
That was a quite different...
Understand. Yes, understand.
Almadeni and Mars is dealt with in our case at Paris 44-47.
Yeah, well, we have read those, yeah. You say the issue was whether Mr. Ng was telling the truth, and the judge adjudicated on that. I understand.
Nothing like...
I understand. The trouble is, looking at other cases isn't particularly helpful. The question is, as Mr. Parker rightly said, it seems to me, the question is ultimately whether it was fair.
But if there was a universal overriding requirement of fairness, which of course there is, nobody would deny that, which entitled a party who has lost on a point which wasn't expressly put to him when he was in the witness box. These cases would be happening every day. I think my Lord Clark said yesterday, 30% of the cases that were decided would have been wrong.
Now, I understand that. The issue is, in this case, Mr. MacDonald, that's nobody says in every case everything must be put. The question is, in this case, was it fair for the judge to make the finding he did on the basis that he did?
But it was fair for him to make the finding that he didn't believe Mr. because he hadn't got he hadn't taken a written confirmation from Madame Chen as he had volunteered himself.
Understand.
He did 3 years earlier. He put forward his explanation. He needs to be asked why he hadn't done it this time. He put forward his explanation in the relevant passage of his witness statement when he said, I didn't do this time because I trusted her. The judge didn't believe that if his story was true, his trust in her would have caused him not to ask her for the written confirmation
Yes, I see.
which he'd obtained on previous occasions.
Okay. Right.
He also didn't believe the story because, thanks to the importance of Mr. to the Katai Strip project, on Mr. Um's own documents,
Yes.
he didn't believe that Mr. Would have thought that his chances would be improved by Madame Chen, as the holder of all the shares in Pexon, advocating the Katai Strip proposal in Beijing.
Okay.
He simply didn't.
No, we understand
He was
that.
entitled not
Yeah,
to believe.
we have that submission. Is there anything else you want to say on that issue?
Do we know this project was to be done through Chong, the company,
Yeah.
in which, as you said, Mr. Gong only had 5%, and the judge appears to have treated Chong as continuing to have a potential interest. He says it couldn't conceivably result in a commercial advantage, that is, to put the shares into Madam Chen's name, to Mr. Nung or Chong Gold in advancing the Kotai Strip development. Was there any explanation by Mr. Nung as to how putting Pexon shares in Madam Chen's name would assist a development which was to be carried out by Chong Gold?
No. I'm glad your lordship has asked me that question, because I should have perhaps said this earlier. He didn't suggest that it was his idea.
That it was what?
His idea.
Mr. Didn't suggest that it was his idea that the project would be furthered by transferring the shares to Madame Chen. He said that she asked him for the shares so that she could promote the Chong Gold project in Beijing.
Yes.
And she wasn't.
We haven't got a very clear picture of who
She
agent
denied
for who.
that.
We haven't got a clear picture as to who was agent for who. It may just be that's the evidence. Who was... Anyway, I said I haven't got a clear picture as to what Pexon's role was. Was it to be agent for Chong, then? Is that...
None of that was... None of the story... Madame Chen's evidence about this was none of this ever happened. Mr. Story was that she said that if she went to Beijing as a person of substance who owned another hotel in Macau,
Yes.
she would be listened to on behalf of the Chong Gold project, and that it was important to do that because of the adverse publicity about Mr.
Right. Anything else?
The judge said that couldn't be right.
Well, we see what the
Because
judge.
Chong Gold was Mr. company. So how would Madame Chen be able to advocate it, whether she held all the shares in Pexon or not?
Yes, very well.
Nothing to do with Pexon.
Very well. Is there anything else on this, Mr. MacDonald?
Well, my lord, perhaps all I really need to say, well, I haven't mentioned Brown and Dunn. My submissions on Brown and Dunn, I'd invite your lordships to consider. They are at some length in our case at pages 107 following.
Thank you.
I will also refer your lordships to the current edition of Phipson.
Yes.
Which does not treat there as being any hard and fast rule about putting everything.
No, well, I think it's common ground between you that ultimately the question is one of fairness. And it seems to me that's rather an imprecise but entirely reasonable test. Very well. Thank you.
Perhaps I should also say that I put the documents to Mr. At the end of my cross-examination in the context of the Kern-Gore letter.
Where do we find that?
Let's see.
Is it page 789?
One again, very near the end.
Where is it?
be in day 2.
Yes, it must have been. Is it page 785? That's where you deal with Kyong Gore. But I don't think there's any documents, one document you mentioned. Well, look, you better find it later if you want to refer to it, but I think in fairness, Mr. Parker, if you're going to rely on it, Mr. Parker ought to know what it is. Well, perhaps if you find it while you or your junior can find it while Mr. Parker's dealing with this and reply, and then we can come back to it if necessary. Thank you very much. Thank you. Mr. Parker, you have a right to reply on this issue.
Much obliged. My Lord, we would say that it's not right to say that Madam Chen suggested that she should front the proposal for Chong Gold. Chong Gold wasn't mentioned by Mr. Ng in his witness statement.
But the
Deals with this
proposal was that Chong Gold should do the development, not that Pexon should do
It
it.
started off with Chong Gold, as we see from the feasibility study, but by the time of October 2011, there's no mention of Chong Gold by.
Well, you said there's no mention, but it doesn't. There's no mention that it had dropped out. He'd had a row with Mr. Gong, but Mr. Gong, the complaint against Mr. Gong was made on behalf of Chong Gold, amongst others.
Indeed, I'm just telling your Lordship
Was there any evidence that Chong Gold had ceased to be the proposed developer between March 2011 and the transaction in issue?
No, there wouldn't be, because effectively the project was stalled because of the publicity with respect to the Social Security.
Well, the project wasn't stalled in this sense. It was proposed to send, according to Mr. Ng, it was proposed to send Mrs. Chen to Beijing to forward the project. And there's no evidence, at least that I've noticed, that by the time that the shares were transferred, allegedly for that purpose, Chong Gold had ceased to be the developer. It was still a Chong Gold project.
Well, there was no evidence either way, as the point being that in terms of the relevant cross-examination, there was no cross-examination about Madam Chen being made the nominee for the proposal being futile, because...
You were suggesting that Pexon was going to be the developer of this.
No, not at all, not at all.
Well, that's
it was
the point, isn't it? The point that the judge made was that it didn't make sense to suppose that Mrs. Cheng would be in a better position to forward the project in Beijing by virtue of being the shareholder of a company that was not involved in the development.
Well, Mr. Ng's point was that she had to present herself as a person of means and could do that through ownership of Pexon. It wasn't in the context of saying she needed to present as being the owner of a company that was putting forward the proposal. The identity of precisely who would be making the proposal that Mr. Ng's referring to in the context of the transfer wasn't a matter that was explored. And Mr. Ng simply referred to it being his project. Now, we can see...
Throughout. He said it was his project throughout. In other words,
yes.
Assuming he was doing it through some company, through Chong.
But when Madam Chen makes her proposal, it becomes her proposal. So the point of your Lordship's point about his fingerprints are all over it, that's the point. The adverse publicity meant that the proposal would have difficulty if it was linked to him because of the adverse publicity.
That postulates, does it, Madam Chen said, I'll go along to Beijing and pretend that this is a Pexon development. The moment they ask for a feasibility study, they'll see it's a Nung development, a Chong Nung.
It doesn't presuppose it's going to be a Pexon proposal. It presupposes that it'll be a proposal where Mr. Ng's involvement in is concealed. And they appreciated that. We can see it's a bit of a nugget.
Consistent with Mr. Ng's evidence, was it? Mr. MacDonald spent a lot of time cross-examining Mr. Ng to suggest that he was a man who would not be received with favour in Beijing because he was a triad leader and all the rest. And your client's evidence was to the effect that he had no problem of that kind. He was a respectable businessman with an excellent record of charitable giving and all the rest. So,
No, because this arose out of it was Madam Chen's proposal that because of the adverse publicity, she should be the one presenting the proposal. But there was no exploration in cross-examination about this futility point. Had there been, the observations I'm making, I would suggest, would have come out in the answers. And we see that they know what the answers would have been. If one looks at my observation at page 155.
Sorry, 155, oh.
Written case, yes.
It's at footnote 35.
Yeah.
There's a reference to what my learned friend was saying before the Court of Appeal. And we'll try and dig out the reference to the writing. Before the Court of Appeal, he was saying that the explanation of the alleged futility, as referred to by the learned judge, was that everyone would be annoyed when the proposal having been, Madam Chen's proposal having been successful and the license having been granted, he then popped up to take over the project because they appreciated, and this is the reason why they were making these submissions before the Court of Appeal, they appreciated that the proposal wasn't going to be put forward as having anything to do with Mr. Ong.
As I understand it, you say that the fact that he defended his reputation in cross-examination doesn't alter the fact that, although he said he was entirely honest and everything else, there were stories about him which meant that, however honest he may or may not have been, he was may have been perceived in Beijing as being dishonest, or what?
Yes, because there was a press article.
There was a press article about it.
So he accepted the problem, and the solution was that he would appear to have nothing to do with it.
And your answer to the feasibility study is that there was no evidence that the feasibility study was going to be produced in Beijing.
Yes.
And he didn't have an opportunity, even if that's not right, he never had an opportunity to say it.
Correct. So I'm saying one can see from the observation in the footnote that they know what the answer would have been from Mr. Ong had this point been put to him, but it was never put to him because the whole question of futility wasn't addressed.
Yes, I see.
Because it's a bad point. And the feasibility study, my Lord Hodge asked me for the references to the feasibility study in my learned friend's closing, and it's referred to the once on page 1527, and it's referred to by the judge.
Yes.
The learned friend is providing some detail about what the project was about, and your lordships will note at line 17, the court says, can I
Line
get...
17 of?
It's page 1527 in bundle 9.
Thank you. Yes.
So, the learned judge says, can I get that from the feasibility study itself? Mr. MacDonald says yes, and then the court says this, I don't think I was actually taken inside it. I think I was shown the cover, if I remember rightly.
Thank you. Yep.
Now, all these points about his fingers being all over it, they didn't feature in the trial. It's something that the court itself thought of subsequently. And then a friend's submissions then go through to 1532. Again, they're all on the assumption that she's going to be presenting, Madam Chen's going to be presenting, the Chong Gold proposal. So we see, for instance, the top of on the top of 1531, putting Chong Gold into her name might achieve that result if the story were true. But that's all proceeding on an erroneous basis, which would have become clear utility point being put, which is why, in my submission, the Court of Appeal is correct to say it's just unfair for the learned judge to have decided this on the basis of the utility point, based on the notion that, well, she, insofar as one tries to understand what he said, the notion that Mr. Ong's fingerprints were all over the proposal. It's a misunderstanding of what was intended. And that, the point, therefore, should have been put. And the Court specifically say that, having therefore reviewed the transcript, that the point should have been put, and we see that 104, and then the fact that they don't think Mr. Ong's story is inherently implausible, therefore is something he should have been cross-examined upon.
Well, I was going to say, I mean, perhaps that deals with the point, but one objection or one problem might be that your client gave extremely vague evidence in support of his case on this aspect, didn't he? But you say it wasn't inherently plausible and it was for the other side to probe his evidence.
Well,
yeah.
Yes. Okay, thank you very much. Now, we have the question of service, of jurisdiction.
There's the application within the further evidence consisting of the Macau 2015 judgment, which was mentioned yesterday as needing about 10 minutes to deal with.
Well, so be it. Yes, well, we better deal with it.
Is this to put this evidence in for the purpose of enabling us to decide the facts, or is the object to put the evidence in for the purpose of demonstrating that it might have to go back for a further trial of the evidence?
Certainly not the latter, my Lord.
I see.
It's simply, it's exactly parallel to the second counter notice.
Yes.
The second counter notice relied on Mr. Ohm's pleading in Macau, which had appeared to abandon the Katai strip story.
Yes.
And we say that should have been admitted, and it would have, looking at it now, one can see that it tends to confirm that the judge's conclusion about the Katai strip story was right. In exactly the same way, the fact that the Macau court rejected the Katai strip story after hearing oral evidence in 2015, we rely on as tending to show that the judge got it right. If his finding, even though it's right, was so tainted with unfairness that it should be set aside, so be it.
But, I mean, either if the judge went wrong as a matter of law in his approach, the first point, then this doesn't help. And if the judge was so unfair in finding Mr. Ng's story unreliable, the second point, how does this evidence help on either point?
Well,
if it goes back, if it doesn't go back, cadet quaestio, if it does go back, that's that.
Challenging a finding of fact on the basis that it's been arrived at unfairly is, as we can see from the authorities, an extremely unusual, or raises an extremely unusual question. If that jurisdiction is sought to be exercised here, it must be relevant that after or since the allegedly unfair, procedurally unfair decision, further evidence has emerged which tends to confirm that the decision was right, whether or not it was tainted by unfairness at its inception.
How could we rely on that evidence? I mean, I quite see that it couldn't have been cross-examined at the trial, but it's difficult for us to weigh that evidence without there being any oral evidence relating to it in any way. None of that, of course, would matter if we were to conclude that the defects of the judgment were such that the matter had to go back anyway. In that event, further evidence would be relevant.
I'm content to leave it like that, my Lord.
Thank you. Right, so we now turn to jurisdiction.
Yes. May I do it by reference to my case, my Lord?
Yes, of course.
Page 116 of the bundle.
Yep.
Paragraph 209. When the proceedings were commenced in August 2012, and at the time of the trial, Mr. Justice Bannister and the Court of Appeal were bound by the Court of Appeal's decision in Nylon. And it's perhaps worth noting that in Nylon, eventually the board decided that Mr. Justice Bannister, who had been the judge at first instance in Nylon, had got it all right, and the Court of Appeal had got it all wrong.
Yes.
But he was obviously bound to follow loyalty the reasoning of the Court of Appeal, and that's why when we started in front of him, we handed up our three-page skeleton, and the first point we made in it was that there was a potential argument on jurisdiction, but it could only be pursued in the Privy Council or possibly the Court of Appeal, and it would entail submitting the Court of Appeals had got it wrong in Nylon.
Isn't the problem altogether more fundamental? There has been a trial of this action. The question is whether it is open to you to reserve your position about jurisdiction in circumstances where, on the face of it, you have submitted to the jurisdiction of the court, having indeed applied to be joined.
The answer to that, my Lord, and we were interested in my learned friend's list of, I think, 8 different meanings of the expression submitting to the jurisdiction. The answer to that is that Nylon shows and lays down that the BVI court, and if it was followed, if what was said in Nylon about Hoycrest, the English decision, if that was followed, it would also apply to the English court under the English Companies Act. But Nylon, the board laid down in Nylon, that under the BVI Companies Act, the statutory jurisdiction which is conferred on the court to rectify the register and to hear and determine issues about the beneficial ownership of shares and so on, which affect claims to be registered, is not exercisable except on the basis that there are shares which should be registered but have not been.
Yes, well, your client controlled the company, Pexon, at this stage. So she could have resisted the jurisdiction when Mr. Nung invoked it against Pexon.
Exactly.
Well, it's all very well saying that there's some previous decision. That often happens. You don't like the decision, so you have to reserve your position by making a challenge and either waiting the result of the challenge in the previous case or else taking your own case up. The last thing you do is effectively submit and then join in a personal capacity, join in the fray.
It's terribly unfair, but you get a one-way option. If you win the case, you say, fine, not taking the point. If you lose, you say, right, I'm taking the point.
After the nylon judgment was handed down, it was our duty to take the point. In Gardi, the English court...
No, it wasn't, because, for exactly the same reasons, because you had waived it, and indeed in the joining Madam Chen, or in applying to join herself, you had voluntarily thrown yourself into the swimming pool.
Lord, we rely on the principle...
Dived in with enthusiasm.
We rely on the principle that the...
Splash.
We rely on the principle that the court jurisdiction, which the court doesn't have under statute...
Depends what you mean by jurisdiction. The court can always decide personal issues, and a large element of this case was about a personal issue between you and Mr. Nung. That's the effect of your joining in. You have fought the personal issue with him.
If Madame Chen and Mr. Had come to the BVI and Mr. Had or commenced proceedings against one another, it wouldn't have mattered which was the claimant and which was the defendant, asking for a determination as to who was the beneficial owner of these shares. The court, I suppose, since neither of them were resident within the jurisdiction, the court of its own motion might have said, well, this isn't the forum convenience for that.
Well, not if neither party was challenging the jurisdiction.
Absolutely. But if they're both there inviting the court to adjudicate,
That's what
the court would do so.
That's what submission to jurisdiction is about. And as regards the company, you say there's no jurisdiction in the formal, technical, fundamental sense, but that's a point which the company didn't take. And I think if it were true, of course, it would continue through to judgment against the company, and the court would have to take it.
Our submissions are based on a strong line of authority, including the decision of the House of Lords in Williams and Glyn's and Astro Dynamico. Would your lordships go to our case at page 122 of the bundle?
One, two, two.
Yes.
Yep, thank you.
Yes.
The House of Lords, disagreeing with Mr. Justice Bingham, held that if the court was to entertain the application for a stay pending an inquiry as to whether guarantees relied on in Greece were forgeries, it would be assuming that it had jurisdiction to entertain the action. That view was mistaken. The fallacy is in confusing two different kinds of jurisdiction. The first is jurisdiction to decide the action on its merits. The second is jurisdiction to decide whether the court has jurisdiction of the former kind.
I don't see what this has got to do with it. I mean, the court in that case plainly would have had jurisdiction to deal with the merits if there had been a submission. All that was being relied on was, what was before it was a challenge to the formal right, presumably to serve out of the jurisdiction, relying on an English jurisdiction clause. But if that challenge hadn't been made, the court would have had every jurisdiction on the basis of a submission.
Well, Lord, may we go back to what had been said in the Wilkinson and Barking Corporation case, which is left out of this quotation from the House of Lords, because we've already quoted it on the previous page.
Yes.
In Wilkinson and Barking Corporation, the corporation relied on a statutory provision that right to superannuation allowances was to be determined by the Minister of Health, whose determination was to be final, see para 228 here above. And Mr. Wilkinson contended that the corporation, having entered an unconditional appearance to the writ, had submitted to the jurisdiction of the court to determine his claim and couldn't rely on Section 35. And rejecting this contention, the Court of Appeal said the real answer can be put in several ways. No act of the parties can create in the courts a jurisdiction which Parliament has said shall vest not in the courts but exclusively in another body. Nor again can a party submit to, so as to make effective, a jurisdiction which does not exist.
Yeah, well, the jurisdiction does exist here. If Madam Chen applied to join on the basis that the dispute was as the ownership of the shares between her and Mr. Nung, and she wished to be joined as a party in order to have that dispute, in order that the court can resolve all matters in dispute, including that. And the matter is, in truth, a personal dispute between the claimant and the applicant, between Mr. Nung and Madam Chen. I'm just reading 2H2, her application to join. So she, as I said, has dived into this jurisdiction, inviting the courts to decide a personal dispute, which anyone can do in any court in the world. I can go to wherever I like. If the other side is willing to have it resolved there, the court has jurisdiction.
Yeah, and she dived in.
So what's
because Mr. has started the proceedings in the BVI.
Yeah.
He served Pexon in the BVI, which of course was the right place to serve Pexon. He hasn't joined her. He's applying for summary judgment against Pexon. And the court in the BVI is bound by the decision of the BVI Court of Appeal that Mr. claim is within its jurisdiction.
But why isn't, once she's added as a defendant, which she's applied to be and succeeded in being, why hasn't the court got jurisdiction to determine the issue as between the claimant and her?
For the reasons which the board explained in Nylon, when it said that although it might be the view taken by the Court of Appeal might be convenient, it was contrary to the proper construction of the BVI Companies Act. And the parallel decision of the English Court of Appeal on the English Companies Act in Poycrest was also wrong.
If this is true, these are points to be taken first by Pexon, which she controlled, and secondly by her, by avoiding going anywhere near the BVI. So, I mean, she's got a double problem. First, that insofar as Pexon could have objected to the jurisdiction, it didn't. And insofar as she is concerned, she positively welcomed the jurisdiction. And maybe she did it because Pexon had objected, but that's a different matter.
In Nylon, there was no trial of the issue. The proceedings relating to the jurisdiction went ahead before that could be approached. In this case, that didn't happen. The court accepted jurisdiction, both parties accepted the jurisdiction, the issue was fairly raised and decided.
The court had to accept jurisdiction because it was bound by
Okay, so the result of that is that there's jurisdiction.
In Nylon, what happened was that, of course, the
court didn't have to object jurisdiction. If Nylon had raised the point, the court might then have said, all right, we're bound, but up you go in the court system.
They could have said, we want to take the Nylon point, and the Court of Appeal might well have said, okay, we'll accept that there's only one answer that we can arrive at on the Nylon point. It's the answer given by the Court of Appeal in Nylon. in which case you then go to the Privy Council. You can go and challenge the jurisdiction right up to the top, but what you can't do is have the entire issue tried out, and then, when the result is unwelcome, say, we now know, retrospectively, so to speak, that we would have succeeded on such a challenge.
Lord, I entirely follow that point, but it doesn't overcome the proposition that the jurisdiction on which Mr. Was relying and continued to rely, because the claim has never been amended.
The jurisdiction to amend the register.
It was his action is an action under the BVI Companies Act, asking the court to exercise its power to rectify
I
the
think we
register.
understand that, but the basic problem is that's not all it was, because the result of your client's successful application to be joined was that an issue was to be determined as between her and Mr. Ung. And that issue was determined. It wasn't at that stage simply a matter between Mr. Ung and the company. It was a matter between Mr. Ung and her.
Well, I follow that, my lord, but the fact is that I would respectfully submit that there is no tenable answer to the proposition that the submission to the jurisdiction did not cure the lack of statutory jurisdiction under the Companies Act. It couldn't have done.
Well, wait a minute.
Because
once Madam Chen has entered the arena and had a resolution of her dispute with Mr. Nung, if that had gone in favour of Mr. Nung, he probably would have done sufficient then to establish a right against Pexon for rectification, but if he hadn't done sufficient, I mean, obviously in the present result, Madam Chen, well, no, under the Court of Appeal decision, he has done that. If he hasn't done enough, then the personal issue has still been resolved by the BVI court, but there won't be any relief against Pexon, and that's all there is to it. I mean, you can't ignore the fact that, as my lord said, there's been a very elaborate issue, a personal issue, tried as a result of a submission to the jurisdiction, and I don't see how you can avoid that conclusion by saying it took place in the context of proceedings against the company, which might originally have been doubtful when the company didn't raise that point. Nobody raised that point. I mean, I imagine that Madam Chen could have raised that point. She could have intervened for the purpose of disputing the jurisdiction against Pexon. It would have been a rather odd thing to do because she controlled Pexon, so she could dispute the jurisdiction in Pexon's name. But she didn't. She didn't do any of that. She intervened to litigate the personal issue.
yes, there was an affidavit, in her original affidavit, I think when she applied to join, she said that she'd been advised that Pexon could oppose the application, but since Pexon, the ownership of Pexon was in dispute, it wouldn't be proper for her to cause Pexon.
That underlines the personal character of her intervention. What you are submitting is that she's entitled to ask the court to decide the personal issue and then say they didn't have jurisdiction to accede to her request or deal with it.
Well, she's entitled to do that because the Court of Appeal's judgment in Pexon has been overturned by the Privy Council in early 2015.
Nylon, yes.
Well, my lord, there it is. I've set out in the written case the problem that would have to be addressed in explaining why the jurisdiction point doesn't work.
We should deliberate on this.
I think probably I would be taking up your lordship's time unjustifiably if I pursued it.
I've gone off there.
Thank you very much, Mr. MacDonald. Thank you.
David.
Mr. Parker, we don't need to trouble you on this point.
I'll just make two points on references. Obviously, the reference in my written case to the relevant transcript of the judgment is wrong. You will have spotted that the Court of Appeal's judgment is at page 2405. So sorry for that.
Just for the record, what are you referring to?
It's
which
pre-reading, item 3. We put transcript.
I beg your pardon, on pre-reading. Yes, I see.
Transcript of judgment on the jurisdictional challenge. We gave a wrong page references. Forgivable given the importance of the document, but it's actually at 2405. We commend, obviously, judgment to you.
Yes, and previality.
And the other reference I'd like to give you is to just to jog back to my submissions on the evidence. My footnote 35, page 155 that we looked at was referring to was my learned friend's submissions, skeleton argument for the Court of Appeal, which is in bundle 12. And the relevant passage is paragraphs 57 to 58 on page over to 2009.
2008 to 2009, 57 to 58. Thank you. Thank you. Good. Well, thank you very much for your oral arguments. Thank you also to all those involved in preparing the written cases. The board will consider this matter and consider what advised humbly to tender to Her Majesty. Court's now adjourned.